Mr. McKay?
Yes. You might proceed.
You may.
Your Honor, the state has rested their case, and I just wanted to remind this court that at the beginning of this trial, I told you that David March is an innocent man, not just because he's presumed innocent, because he was actually innocent. And after sitting here during this trial and watching these witnesses testify and listening to what I have to say, it is extremely clear that David March is an actually innocent man. This innocent man sits before you today charged with 3 specific crimes: conspiracy, obstruction of justice, and official misconduct. The evidence is lacking so much in this case regarding all 3 of these charges. I submit to Your Honor that as a matter of law, you must direct this case out. Find David March not guilty at this juncture. And I'm not clear, Your Honor, whether your standard of review at this juncture in a bench trial after the state has rested is that you're going to view the state's evidence in the light most favorable to them, or are you judging their evidence that they presented beyond a reasonable doubt? Regardless of what your standard of review is here, I submit you must direct this case out regarding David March. That's how lacking the state's evidence is in this particular case. Keep this in mind. The conspiracy charge states that David March, Joseph Walsh, and Thomas Gaffney, with the intent that official misconduct be committed and with the intent that obstruction of justice be committed, they agreed with each other, Officer Van Dyke, and other known and unknown co-conspirators. A couple of things. There is no evidence at this point that David March and Joseph Walsh and Thomas Gaffney even met each other before that night. None whatsoever. There's no evidence that David March, Joseph Walsh, and Thomas Gaffney communicated with each other after that night. And keep this in mind. This conspiracy charge states that the goal of this conspiracy was to conceal the true facts in order to shield Jason Van Dyke from investigation and prosecution. Not or, and. And that it was their intent to keep these facts from independent criminal investigators and that the public would not see the video. Judge, David March inventoried the video in this case. He saved this video for these people to use against him. How in God's name is David March conspiring to conceal the true facts when he's saving the video for the world to see now? That's not the act of a co-conspirator with the intent to shield Jason Van Dyke from an investigation and prosecution. And by the way, he just didn't inventory the video of A13 Robert, which everybody clings to as the absolute truth. He also inventoried A45 Robert's video. He and another detective inventoried videos from Dunkin' Donuts. He's preserving evidence in this case. It's important to Mr. Maris to collect and save and preserve information. It was important to David March that night and every day following to preserve the evidence in this particular case. He was at the scene that night. And according to the police reports, which the state introduced into evidence, you know, Your Honor, that David March was overseeing the collection of evidence done by the evidence technicians that night. All 16 shell casings were picked up by evidence technicians under the supervision of David March. If he was conspiring to conceal the true facts, how about him picking up about 7 or 8 shell casings and putting them in his pocket? How about taking that video from 813 Robert and throwing it in the middle of Lake Michigan? It is shameful that David March, an innocent man, is sitting here charged with these crimes when he gave all the evidence to these prosecutors. And by the way, the goal of this conspiracy, according to the special prosecutors, is to shield Jason Van Dyke from investigation and prosecution. That's a laugh. You know from the evidence, Judge, from the witness that testified, you know that the Cook County State's Attorney's Office and the FBI were conducting interviews in January of 2015. You know that not only was the Cook County State's Attorney's Office involved in an investigation, so was the U.S. Attorney's Office. You know from witnesses who testified and were impeached by federal grand jury testimony, the federal government was involved in this investigation in 2015. You know that in addition to the FBI, the U.S. Attorney's Office, the Cook County State's Attorney's Office, the Office of the Inspector General was taking sworn statements from people in this case. To charge David March and others that they are hiding facts from independent criminal investigators, that's a laugh. That's a joke. A bad one, but that's a joke. Heck, IPRA, the Independent Police Review Authority, was out at the scene that night. If you look at the police reports submitted by David March, he listed 4 IPRA workers at the scene that night. 4 of them. How is that hiding facts from independent police investigators? And to further show how ridiculous this indictment is, this indictment alleges that David March, Joe Walsh, Tom Gaffney, and others conspired so the public would not see the video. David March has no authority or ability to hide video evidence from the public or give it to the public. Those decisions are made by people downtown, like in City Hall, people that might be running for an election. David March saved this video. How in God's name does any of this evidence prove that he's shielding this evidence from the public? And before we talk about a conspiracy, we have to prove that there's an agreement. Where is there evidence that David March agreed with Joseph Walsh and Thomas Gaffney or anybody else in this case to perform some illegal act? Where is your agreement? What you know is, Judge, based on the testimony that you've heard, David March is conducting independent interviews at the scene that night. He's taking one officer at a time, asking these officers what they saw. Now, did these officers see the video at the time of his interviews? No. But David March is a reporter at that moment. He is a reporter. His job is to write down what these witnesses tell him. He is not a judge. He's not an editor. He's supposed to write down what they say. Whether David March believes that or not, he is duty-bound to write a summary down of what these witnesses tell him. He cannot, in fact, he would be violating general orders and other rules and regulations that these prosecutors suggest. He would be violating it if David March didn't write down these words that these witnesses said to him. If a witness tells him a lie and he believes it to be a lie, Dave still has to write down those words. He doesn't have an option of reporting something Dave March feels is correct. Yet he's on trial because he took down notes. He took notes. Yet they want you to rely on testimony like people from like Earl Briggs who didn't take any notes. There is no evidence of an agreement. It doesn't have to be direct. It could be implied, but there is no evidence that an agreement was implied. The prosecution kept saying throughout this case, parallel false reports. These are false reports. They keep spitting out the word false reports as if it's true. It's not. The more they say it, the more they want you to believe it because they don't have the evidence to prove it. Look, we can all look at a video and interpret different things. Dave is merely an investigator writing out what witnesses tell him. Regarding this conspiracy, the state put in emails. Now, Mr. Mayor's told us in no uncertain terms that the Chicago Police Department email system maintains, keeps, preserves all of the emails. Well, it begs the question, if David March was involved in a conspiracy, show us one email from him. Show us one email where he's copied by these other people, some of whom don't even live in this state. There is none. And if there was one, you would have seen it. You would have heard it. They would have asked Mr. Maris to identify it. They didn't. The only email is an email that's dated March 15th at 10:33 p.m., and it's from his supervisor. And it's a conclusion. It's a couple of sentences. Judge, how about showing us a reply email from Dave March? The police reports are submitted on that date. Show us some type of collusion. Show it. These other emails are absolutely ridiculous. You have emails from Anthony Wojcik, Daniel Gallagher, Ron Hostow from the Law Enforcement Legal Defense Fund, Tom McDonough from Chicago FOP. If those emails were truly in furtherance of the conspiracy, those men should be sitting here too. Aren't they reports? Aren't they writings that show this grand conspiracy? Judge, the police reports written by David March were included in the state's evidence. And we have a number of supplementary reports. One's 23 pages, another one's another 23 pages, another one's like 7 or 8 pages. There are evidence submission forms prepared by David March from the Illinois State Police Crime Lab, listing all of the evidence that's collected in this case. And Dave is saying through those reports to the crime lab, another independent police agency, work this evidence up. Don't hide a thing. In addition, all of the inventory slips in this particular case with David March's name on it is preserving evidence. All of the GPRs in this case, all of the general progress reports in this case were written by David March. All of them. One of the state's witnesses, Joseph McGilligan, said, when he looked at the GPR of his interview, he said, yep, that's an accurate summary of what I told Detective March. Yes, sir. The only person who came into this court in the state's case and said, I didn't say one thing in Dave March's GPR was Dora Fontaine. Get to her in a second. But all of the other GPRs in this particular case that are made part of the file here, no officer came into court and said, I didn't say that. So let's take a look at Dora Fontaine. Dora Fontaine has testified so many times, I lost count. But it wasn't until she's threatened with being fired does she mysteriously become a witness. She doesn't even know why she's a witness. That's a lot of baloney. But you know, Your Honor, that prior, under oath, inconsistent statements can be used as substantive evidence, meaning you, as the trier of fact, can consider her prior under oath statements as something that is like as if she's saying it in the courtroom today. The believability of a witness may be challenged by evidence that on some former occasion he made a statement that was not consistent with his testimony in this case. Evidence of this kind, ordinarily, may be considered by you only for the limited purpose of deciding the weight to be given the testimony you heard from the witness in this courtroom. However, you may consider a witness's earlier inconsistent statement as evidence without this limitation when the statement was made under oath at a prior hearing or proceeding, or the statement was accurately recorded by a tape recorder, videotape recording, or other similar electronic means of sound recording. So when Dora Fontaine said under oath that she saw McDonald making attacking movements, you, Your Honor, can consider it as if she said that in this courtroom today. No matter how far she wants to distance herself from the statement that the offender ignored, raised his right arm as if to attack Van Dyke. She said it under oath a long time before she ever walked into this building that she saw McDonald making attacking moves. You can consider that, Your Honor. In addition to that, when she told the Inspector General under oath, with her lawyer sitting right next to her, that she doesn't recall telling David March that the offender raised his right arm as if to attack Van Dyke, you can consider that as if she said it today. Dora Fontaine lied to you. You know, I can understand. She's in a position where she's a mom, she's got 2 kids. The job that she has is better than anything she's ever had in her career. She prefers sitting behind the desk right now. She's trying to save herself. And you know, Your Honor, that as a trier of fact, you're the sole judge of the believability of witnesses. You know that when you consider the testimony of any witness, you may take into account his ability and opportunity to observe, his age, his memory, his manner while testifying, any interest, bias, or prejudice that he may have, and the reasonableness of his testimony considered in light of all of the evidence in this case. Her interest, her bias, her motive to lie is crystal clear. But let's think about what she said. She admitted to this court that David March at the area did not tell her what to say, did not suggest her answers to give, did not pressure her in any way, did not direct her what to say, what to look at, did none of those things. And she admitted that when they went over the video, she agreed. She agreed with David March that that's where McDonald was turning. What she wants this court to believe is that everything she said to David March on the street, she said, but for one line. And that line reads, the offender ignored, raised his right arm as if to attack Van Dyke. Well, let's talk about that. The evidence in this case that you have before you is David March wrote, 50, 80 pages of reports, single space. And if you believe Fontaine, one line isn't true. Is that proof beyond a reasonable doubt? That's ridiculous. The state wants you to criminalize police reports, which, as you know, Judge, are never given to juries. They're not evidence in most cases. They are summaries. Jurors ask for police reports all the time. Judges say no. There's a reason. Yet the state wants you to believe that one line out of all of those pages, in this case, written by this man who wasn't there, amounts to obstruction of justice, official misconduct, and conspiracy. But let's talk about this then. She admitted to this court that she heard several times police saying, drop the knife, drop the knife, drop the knife. Well, you know from the video that Dave Mark preserved for you to see, McDonald doesn't drop the knife. What does that mean? He ignored police commands. So what is she saying? I didn't say that part of the sentence, even though it's true. Well, if that's the case, Dave March wins. And then further, the offender raised his right arm. I showed in this courtroom that this is raising your right arm. She agreed with that. But what happened, Your Honor, is when the prosecution wants to ask Fontaine questions, how do they pose their question? Did McDonald raise his arm over his shoulder, over his head? No. They want to give the inference that raising right arm means those other things. Well, here's the problem with that prosecution theory. Dave didn't write it. He didn't write, he raised right arm over shoulder, raised right arm over head. Dave never wrote those things. They want to show you by body movements. They want you to hear it through their questions. But that's not what Dave wrote. They're stretching it more than could be. You know, in gang cases, as a prosecutor, we used to call a person who kind of rolled over and everybody else a flipper. Dora Fontaine's not a flipper. She's a flip-flopper. She keeps going back and forth, back and forth, back and forth. Every time she changes her story, Your Honor, that's reasonable doubt. You cannot find her credible. There was substantial impeachment of Dora Fontaine that you should, I submit, reject her testimony. This is a criminal courtroom. This is not a civil courtroom where the burden of proof is beyond, by a preponderance. 51% doesn't cut it in here. It's proof beyond a reasonable doubt. And every time Dora Fontaine flip-flops, she's telling you, I can't be believed. And what kind of a person is she like that? What kind of a police officer is she? Well, she's the kind of police officer who, as soon as her tour of duty begins, she turns the radio down and makes a personal call. That's the kind of police officer this city wants, and not a professional, an honest, decent man like David March. If that's the case, every citizen of this city is in trouble. In fact, we know from the evidence, even from her own mouth, her partner, Vera Montez, comes out of the Dunkin' Donuts and is telling her, hey, we got to go. There's a call for assistance. She didn't know this because her radio's off. That's how she served and protects the citizens of Chicago. Vera Montez had to run out and tell her they've got to be the police that night. Vera Montez did not come in this courtroom and said David March is lying about his interview. You saw the testimony of Dora Fontaine. You are the judge of the believability of her testimony. You know she was a bitch. You know she cannot be believed, not in a criminal courtroom with this burden of proof. And then we have Earl Briggs. Again, over our objection, respectfully, Earl Briggs is allowed to testify. Why? Why? If Dora Fontaine and the evidence in this case was so great, the state wouldn't need to put on Earl Briggs. That is a red flag to you, Judge. Hey, Judge, our case states we're going to put on this medical examiner, quote-unquote, investigator. And what does he say? He says he's taking a phone call from somebody who claims to be David March. All right. And this person, David March, tells him, among other things, that McDonald lunged at the officer. Really? Okay. Well, how about Mr. Briggs taking a note? Are we asking that? Are we asking too much for this guy who's sitting behind a desk in his midnight shift who won't go out to the crime scene? Is it too much to ask Mr. Briggs to write down a note? Because he didn't. Yet the state wants to use Dave March's notes against Dave March. Not fair. But again, let's talk about Earl Briggs. He wants this world to believe that that report that he stands by, all of it came from Dave March. It's a crock. Why? Well, there's another report that he doesn't want to acknowledge, which shows that that report was changed. There's something funny going on at the medical examiner's office with Earl Briggs' name all over it. That report was changed. And Briggs wants to tell this court that from his desk on the phone with David March, he's reading over to Dave March what March just told him. And that would include words like on or about October 19th. First of all, it's the wrong date, but neither is it may. On or about, those are words lawyers use. All right? For Briggs to say that's exactly what Dave March told him is a crock. Briggs got the wrong beat number. He got information that Dave March could not possibly have while Dave March is at the scene. Dave March doesn't know where all the bullet wounds are. Maybe that's from a hospital where McDonald's at, but not from David March. It's impossible for David March to have that information and relay it to Briggs. Impossible. But here's the best. Here's the best, Judge. The police reports submitted by the state with David March's name as the author belie the allegation by Briggs that the word lunged was used. Nowhere in David March's reports does he use the word lunge. No witness who David March interviewed and documented on a general progress report said the word lunge. Lunge didn't come from David March, nor anybody he talked to. You know who it came from? A media person named Pat Camden, who worked for Chicago FOP, not the Chicago Police Department. There's no checks and balances for the media. David March didn't say lunge, never wrote it. Why does Earl Briggs testify? Because their case stinks. And then they called Jose Torres. Well, Jose Torres is riding in a car with his son on the way to the hospital. His son wanted Dad to take off. No police officer told Jose Torres, leave the scene. There's no word spoken by any police officer, who, by the way, is in uniform, not plain clothes with a suit and tie on like David March would be that night. No police officer told him, leave the scene. Don't leave any contact information. That was never said. But Jose Torres wants you to believe that somehow that unknown police officer, who he can't describe, is shooing him away from the scene. Could we please see Dunkin' Donuts video number 1? Your Honor, this is Dunkin' Donuts video 1. It is looking westbound. That is Pulaski Avenue in front. Can you fast forward to where the police car shows? Stop. Keep going. Stop right there. Now look, as you know from the evidence, this is Joe Walsh and Van Dyke's police cruiser. As you can see, there's another police car coming. Take a look at the east curb, the curb closest to the Dunkin' Donuts parking lot. Do you see any car, any civilian car there that is within 2 car lengths of the shooting? No. Torres was adamant, I'm only 2 car lengths away from the shooting. The Dunkin' Donuts video contradicts Jose Torres. How ironic that the special prosecutors allege that police reporters in this case are lying because the video contradicts the reports. Yet we're supposed to believe Jose Torres? There is no civilian car on the east curb. He's not 2 car lengths away. I submit he's so further south by focal point, it's a football field away. And by the way, let's talk about this unknown police officer that Torres can't describe. Do you know why police officers with flashlights are directing traffic? Not to shoo away witnesses, to allow an ambulance to get to that scene. Even Torres says, as he did the U-turn and went southbound Pulaski, he did see an ambulance. What he also said is, no other police officer, with a flashlight or not, kept him going. Nobody southbound. Nothing stopped Torres from stopping his car in southbound lanes and providing contact information to police officers long before Dave March ever gets there. Dave March is on trial for not interviewing Jose Torres. You've got to be kidding me. He's not there. He can't interview somebody whose name he does not know. He can't interview somebody who is not coming forward. He can't interview somebody that's only going to an agenda-driven reporter. How about, Mr. Torres, you call the Illinois State Police, the Cook County Sheriff, the U.S. Attorney's Office, anybody, if you don't want to call Chicago Police, okay, fine. Then call some other independent police agency. He didn't even do that. And they want to blame Dave March? That's not fair. It's impossible for David March, the human being, to interview somebody he's never been told about. And indeed is hidden from. There's no evidence whatsoever of an agreement between David March, Joseph Walsh, and Thomas Gaffney or anybody else. Because if you really got to stretch it to believe this prosecution theory. If true, Dave March decided within minutes of showing up at the scene to take statements from people he never met before, and then with their agreement, without even talking about it, they're going to put a case together to make it better for Jason Van Dyke. That's ridiculous. No evidence whatsoever that anybody's at the area talking to get their story straight. In fact, there's no evidence that David March is at the area until Fontaine says much later on, he shows up and they look at video together where she agrees with everything and doesn't have a problem with what David March is saying. A couple of things need to be said regarding the specific counts of conspiracy. It's alleged that the original case incident report was part of this conspiracy that included that McDonald committed aggravated assaults against 3 officers, finally forcing Officer A, that's Van Dyke, a defense of his life to shoot and kill McDonald, was prepared and submitted by David March and received and approved by Sergeant Gallagher. False. David March didn't prepare that report. Their star witness Fontaine did. And when you see David March's name on that report, there's no evidence that he reviewed it, that he approved it, that he prepared it, that he submitted it. Or they want you to believe that in their questions, but even you caught it, Judge, that Fontaine's report didn't say Dave March reviewed it, submitted it, prepared it, reviewed it. You even caught that. It's further part of conspiracy. Chicago Police Department General Progress Report included at 12 to 15 feet, offender swung knife at police officer in aggressive manner. And that Van Dyke continued firing as offender attempted to get up. Who said that to Dave March? They didn't offer it. No witness came and said, hey, I didn't say that to Dave March. Okay? They didn't prove that. They didn't prove anything in this conspiracy. We heard no evidence from Fontaine's partner, Officer Viramontes. We heard no evidence from Officer Mondragon or Sebastian. We heard no evidence from Officer Velez was there. No officers come in here and say under oath, Dave March wrote down something I didn't say. And when Dave March concludes in his closing stuff, months later, but before these cockamamie emails, his opinion is based on all the evidence in this case that he collected, that he reviewed, everything from the very first witness statement until the PCP in McDonald's case, everything, the physical evidence in this case, the videos, everything, he believed in his opinion. He found it to be consistent. The video was consistent with counts of the witnesses. That's an opinion, Judge. That is an opinion. Larry Snelling can come in and have an opinion. Witnesses come into court all the time and give opinions. They want to criminalize the opinion of an experienced police detective who can only garner information by doing interviews, collecting evidence, looking at everything, and then coming up with an opinion that's based on fact and law. Like the law we discussed with Larry Snelling, the law of aggravated assault. What is an aggravated assault? Who is the offender of the aggravated assaults? McDonald. Who are the victims of the aggravated assault? Well, it started with a civilian named Rudy Barillas, okay? Who apparently, if you believe this nonsense, Rudy Barillas is an unindicted co-conspirator. A middle-aged truck driver with his wife who was attacked at knife point by McDonald. Who was another victim? Tom Gaffney, sitting in his vehicle, tire stabbed with so much force that tire deflated. And then further, as Snelling told you, McDonald was attacking Gaffney, not just the car, he was attacking Officer Gaffney. Gaffney's a victim of an aggravated assault. And whether Joe McElligott wants to feel threatened or not, Joe McElligott is a victim of an aggravated assault in Dave March's report. Conversely, not in Dora Fontaine's. What does that tell you? They're not getting their story straight. There's no conspiracy. But aggravated assault alleges that the assault, the actions of the defendant was placed another in a reasonable apprehension of receiving battery. Not imminent. It's only reasonable. And Dave March, with his experience, can opine that Joe McElligott's a victim too. And as is Joe Walsh and Dan Dyke. You don't agree with that opinion? Fine. That's your right. You think video may conflict with that opinion? Fine. That's anybody's right. But it's not a crime. It's not a crime for Dave March to have an opinion based on all the evidence in his case, and including in that opinion all of his experience and his knowledge and his honesty and intellect. It's further alleged that David March and others failed to locate, identify, and interview witnesses or to ensure the location, identification, or interview of witnesses of the fatal shooting of Laquan McDonald, including witness A, B, and C, not or, and, whose information was inconsistent with the accounts of the Chicago Police Department members. We only heard from Jose Torres, whose credibility, as we see from the video, is suspect, to say the least. Where's all the other witnesses they failed to locate, identify, and interview? They have the burden of proof. They came up short. It's further the part of the conspiracy that March and others failed to locate, identify, preserve physical evidence, or to ensure the location, identification, or preservation of physical evidence, including video and photographic evidence. Again, Dave March preserved the video for everybody. He also made sure the ETs collected everything at the scene. This allegation is ridiculous. There's no evidence to prove it. In fact, just the opposite is true. It's further part of the conspiracy that March, Walsh, Gaffney, Dan Dyke, and others known and unknown to the grand jury used various means to communicate with each other in order to coordinate the activities of conspiracy. What? Use various means? These emails? Hey, show me an email from David March. Show me an email that's sent to David March regarding all of these requests for scientific research and FBI statistics. That's another one. One of their exhibits is an email chain with FBI agents. I guess the FBI are co-conspirators in this case. That's how ridiculous this conspiracy is. They allege David March, Gaffney, Walsh, and others deleted or failed to preserve communication. Really? Where's the evidence of that? None. None. Mr. Maris, come on in. Show us all the deleted communication. They alleged the conspiracy was done to commit both official misconduct and obstruction of justice. When you take a look at the obstruction of justice charge, they allege that David March and the co-defendants committed obstruction of justice when each, with intent to prevent the apprehension, obstruct the prosecution, and, not or, and obstruct the defense of any person knowingly furnished false information. A couple of things. They bit off more than they could chew. They put all three options in. The statute says only one is necessary. Or you do one or the other. You can either prevent the apprehension, or you can obstruct the prosecution, or you can obstruct the defense of any person. They throw it all in. Well, it can't be both. It can't be both. You can't obstruct the prosecution and obstruct the defense. You can't do that. They mischarged it. This count's got to go out because they didn't correct this. And worse, where's the intent? Where's the intent that David March did anything to do any of these acts to prevent the apprehension of Van Dyke? Well, that didn't work. To obstruct the prosecution? Well, that didn't work. Anita Alvarez indicted Van Dyke. How about this one, Judge? This man sitting over here, David March, was called by the prosecution of Van Dyke. Not once, but twice. Once was at a pre-trial hearing to determine whether Van Dyke's statements were compelled. And secondly, he was called in rebuttal of Van Dyke's testimony. It was stipulated testimony, but the prosecutor called David March. And it begs the question, if David March, if his words are relied on by the prosecutor in the Van Dyke case, how in God's name could he be prosecuted for those same words here? That's not fair. That's not due process.
Mr. McKay, that wasn't testified to at this trial. I know there's no objection, and I know this is argument, but there's no evidence of that at this trial. So the court's not going to consider that.
Yes. There is no intent. No intent by David March to do any of those acts they allege in this count two, and they allege all three have. There is no intent. If there were intent, then I could see, hey, let's toss the video link. Hey, why don't you pick up about 9 or 10 of those shell casings, Mr. Carl Brasic, and throw them down the sewer. All right? Hey, let's take McDonald's fingerprints and put it all over that knife. Yeah, I get that. He saved evidence for any case, this one or any other case in this book. Shame on them to put this innocent man here tonight. And lastly, Your Honor, the charge of official misconduct alleges that David March, along with the co-defendants, committed official misconduct when being a public officer in his official capacity intentionally or recklessly failed to perform any mandatory duty as required by law and knowingly performed any act which he or she knows is forbidden by law to perform. There is no evidence that Dave March intentionally or even recklessly did anything in this particular case. Again, he's a reporter. He writes down what the witness tells him. He's being blamed for maintaining notes of his interview. This is ridiculous. Dora Fontaine wrote a original case incident report where, what? She writes down the officer's name and star numbers? Okay. Maybe gets the RD, maybe not. She wants you to believe that Dave March put everything in the report. He didn't. That's nonsense. And she finally relented. Well, yeah, there's nothing unusual about getting information from detectives. The detective's job is to get information from witnesses. She didn't lift a finger. So she can't put in her report what the investigation showed. There's nothing unusual about that. That's protocol, as she testified under oath. Judge, you heard all the evidence in this particular case. The motion for directed finding, I submit, must be granted now because the case against this defendant, David Marks, is so weak. You have the authority to throw it out now. Nothing against the special prosecutors. It's not their fault that the evidence is lacking. But it's not Dave March's fault that their case is lacking. At this juncture of the proceedings, Your Honor, based on everything that you've heard, the incredible testimony of Dora Fontaine, the incredible testimony of Earl Briggs, the ridiculous testimony of Jose Torres, who somehow is placing a duty on detectives who aren't even at crime scenes yet to find him without telling anybody in the world who he is. That, Your Honor, is what that and everything else in this case is so lacking here. That as a matter of law, Your Honor, I submit to you, you must find Dave Marks not guilty right now.
Thank you. Mr. Pugh?
Your Honor, when this case started, I predicted for you that you would find, after hearing all the evidence, that Joe Walsh held a very small and discrete portion of the evidence in this case. By the conclusion of the evidence today, you see that they presented evidence that began on October 20th and seemed to end somewhere on early December 7th, I think, of 2015. And then, as I told you in the beginning, I held to my word. Joe Walsh was just a patrolman on October 20th that night, and he completed 2 fill-in-the-blank reports, which were vetted by 3 levels of supervisors, and he went home. And he returned to work the next day or the day after in the 8th district, where he had been for about 16 years, the same district where he lived with his wife and his family. The huge binders before you of exhibits in this case. There's not a single email from Joe Walsh. There's not a supplemental report. There's not a handwritten note. There are no incident reports. There's no reports of any type from Joe Walsh other than the 2 that I've already described for you, and that his involvement in this case really ended about as quickly as it began. One issue that did come up during the trial, and you saw the beginning of Dunkin' Donuts 1 and 2 here. I encourage the court to take a look closely at those. I think if you look at those, in all fairness, you're going to see Joe Walsh backpedaling slightly when he gets out of his police vehicle that night prior to Jason Van Dyke shooting Laquan McDonald. And again, once you review that evidence, I don't think there's going to be any issue at all as you would be able to find that. In the beginning, the prosecutor made an opening statement, and during the course of this trial, to sort of repeatedly use the term that on that night of October 20th of 2014, Joe Walsh and others got together and started to, quote, shape the narrative. That was the term that was used. And, you know, I got to be frank with you, in reviewing my notes in the course of this trial and looking at all the evidence and thumbing through the exhibits, it really appears that the state in this case has really gone about reshaping the narrative of how a criminal trial is supposed to work and have engaged in some burden shifting here. Repeatedly, the state's advanced the defense of Laquan McDonald in that they have proven him not guilty of the offense of aggravated assault. We've seen that through witnesses and through questioning. Look at the video. The video doesn't match up with this, that there was no aggravated assault here. And to a certain extent, I think the defense on this side, certainly myself included, has kind of taken the bait, and we've become the prosecutors of Laquan McDonald through our defense in this case, and to a certain extent, the defenders of Jason Van Dyke. I think it's important to remember, at least for my purposes, and I hope for the court's purposes as well, is that we represent Patrolman Joe Walsh. We're not here to prosecute Laquan McDonald for misdemeanor offense of aggravated assault, nor are we here to defend Jason Van Dyke and his actions. And what counsel has to prove in this case, the state does, and they haven't really mentioned it. They didn't mention their own thing and haven't really heard much of it during the way. And I hope they'll be reminded of what they need to prove beyond a reasonable doubt. And what they have to prove beyond a reasonable doubt in this case is that Joseph Walsh's observations on October 20th, 2014, that he believed that Laquan McDonald was committing an aggravated assault when Laquan McDonald approached him and another police officer, swinging a knife, looking at him, ignoring commands, not saying anything, is that that belief that an aggravated assault was occurring at this time was not just mistaken on the part of Joe Walsh, but that it was intentionally manufactured at that time by Joe Walsh with the intent to obstruct the prosecution of Jason Van Dyke. The state hasn't even come close to meeting their burden as to proving that. Perhaps most importantly, the state also has to prove that on October 20th, 2014, after Joe Walsh manufactured something that I guess they say he did not see, he willingly agreed and joined a conspiracy with others to do the same, which was to commit the offense of obstruction of justice and a misconduct. And they just haven't come close to do that in this case. And the state continues to submit that in terms of the conspiracy charge in this case, that the presence of parallel falsehoods are evidence of a conspiracy. And if you assume that that's accurate, then I would suggest to the court that parallel inconsistencies are evidence of no collusion. And if you see the reports, and all the reports in this case, which, as the court's aware, all the reports under this RG number need to be reviewed collectively. You look at the OCIR in this case, authored by Officer Fontaine. In there, references that Jason Van Dyke was injured. That is not consistent with the other reports submitted in this case, and perhaps most importantly, the report submitted by Joe Walsh. If you look at the references in the supplemental reports, you see that Joe McElliott is referenced at one point in time as being a victim of assault, but in other reports that have also been submitted, he is not an assault victim. The TRRs in the assailant battery, the SUPs actually, I need to be reading in conjunction, there's actually 23 witnesses in those SUPs that are interviewed that have been submitted to the court for review. If you look at that, in all of those statements of witnesses who were present on the scene, there's not a single witness in there that alleges that Laquan McDonald battered anybody, in particular Joe Walsh or Jason Van Dyke. So again, that's another inconsistency. If you look into Marsh SUP 2, you will see the statements that are contained in there that purport to be those of Jason Van Dyke, Joe Walsh, Daphne Sebastian, who was an on-scene officer. And all of those on-scene officers were present at the same time in those reports. They're not entirely consistent with everything that happened there, which is to be expected. Every witness to an incident is not going to be absolutely consistent with the next. So using their own logic that parallel consistency somehow prove the existence of a conspiracy, I suggest to the court that parallel inconsistencies prove exactly the opposite. The other thing that's disturbingly lacking in this case is the presence of motive. And of course, the state's not required to prove a motive in the case, but Judge, you know that based on the law, the absence of motive is certainly something for the court to consider when determining whether or not the state's met their burden of proof beyond a reasonable doubt. Did you hear any evidence in this case as to how long Joe Walsh was Van Dyke's partner? Or in particular, whether or not any personal relationship at all existed between Van Dyke or Walsh? Were they friends? Was there a single social event they were present for? Were they ever present in each other's personal lives before October 20th, 2014, or on any given time thereafter? We don't have any of that information because, quite frankly, it doesn't exist. And certainly no kind of motive that would certainly suggest that Joe Walsh would give up his career, give up everything that was important in his life just to cover for this fellow Jason Van Dyke, other than this sort of general we've heard before, well, all police officers, I guess, in Chicago do this for other officers. First of all, there's no evidence of that in this trial. Second of all, I think it smacks in the contrary to our common sense in this case. So I just want to talk a little bit about the evidence summary in this case and what you heard as it related to Joe Walsh. And the first witness the state called was this Joseph Perfetti. You got all the police reports and the general orders from him. And in particular, you got the March case supplement 2. And I call your attention within March case supplement 2 to the summarized statements of Daphne Sebastian and Janet Mondragon, 2 police officers who were on scene. And both Officer Sebastian and Officer Mondragon actually say the following in these reports. First of all, as Sebastian states that Laquan McDonald turned towards the officers waving the knife, and they continued to advance on the officers waving the knife. And Officer Mondragon states that Laquan McDonald got closer, continuing to wave the knife. Those statements have been entered into evidence by the state in this case, and I guess we'll just have to take those as true because those are the statements that the officer made. And those statements are consistent, actually, in many respects, with the two reports that are attributed to Joe Walsh. And in terms of any other statement that Joe Walsh provided in this case, you do have a statement of his co-defendant in this case that's contained in those reports, but there's certainly no evidence that Joe actually made any statements during the course of his investigation to anyone. Earl Briggs, witness number 2, irrelevant to Joe Walsh. Sergeant Snelling. Sergeant Snelling told you a few things that I think are important as to Joe Walsh in this case. First of all, he told you that there's a fine line between an active resistor and an active assailant in this case. And whether or not you find from looking at one video whether or not Laquan was an active assailant or was he an active resistor, that's a determination that the officer at the scene made, who was there from his perspective watching what occurred. And even an expert such as Sergeant Snelling, who's been teaching this for a number of years, he told you how limited the video was. He reviewed 815R dash. Curiously, the state didn't provide Sergeant Snelling with the Dunkin' Donuts video, or they didn't provide him with the Chicago food depository video to review in this case, or the last videos that came in today, which are the focal point. They didn't give him that. They didn't provide him with the narratives of what happened with Mr. McDonald prior to the arrival of Van Dyke and Joe Walsh. And I think that's quite, in all fairness, Sergeant Snelling would say those are things that he would have wanted to look at if he wanted a more complete opinion from him in this case. And yet the state, just as recently as a few moments ago, got up here and talked about emphatically what Sergeant Snelling's testimony was. Well, they controlled the narrative as to what Sergeant Snelling's testimony would be, because they controlled the materials they gave him to review. He did tell you, though, concerning Laquan McDonald, in the limited video that he watched, he observes McDonald having what he says the weapon system, the delivery system is present. He said the only thing that he couldn't see was the intent system. What does that mean? It meant that by what Snelling reviewed in this case, when Joe Walsh is confronted with Laquan McDonald, he's finding an offender who has the weapon system and the delivery system present, ready, and that the only thing that's missing is this intent system. But on cross-examination, he admits that McDonald has his back to him in this video. He can't see where his arm, who has the knife, is at that time. And he does see him look in that direction, wearing Mr. Green's cross. He did admit he can't tell you what's on the dark side of the moon. He admits that in the Gaffney incident, that Laquan McDonald was absolutely an armed assailant at that time. And he also explains for you, Judge, how Joe Walsh's TRR and OBR would go through an approval process. That TRR and OBR would first have to be submitted to a sergeant. That sergeant could send it back, have it corrected or anything. It then goes to a lieutenant, and then it goes to a commander. And it can be accepted or rejected at any point in time. And I think it's important because they've offered the TRRs and the OBRs as a statement of Joe Walsh. But it's not just a statement of Joe Walsh. It's a statement of Joe Walsh with the review by 3 levels of superiors above him in this case. And there's certainly been no evidence that those 3 levels of superiors, all the way up to the commander, the area commander in the case, was somehow colluding with Joe Walsh to make sure that his TRR and OBR was reflected in a particular way. Sergeant Snelling also told you that the decisions about whether or not someone is being assaulted are split-second decisions, and that the scene officers, that being Joe Walsh, has a better perspective than 815R, and that exhibit suffered from a disability. He admits that Laquan McDonald was an armed assailant at some point, and Officer Fontaine actually corroborated that when she told you, and when she arrived at the scene and saw Laquan McDonald coming towards the location of both Joe Walsh and his partner, that she described him based on her training that he was an armed assailant at that time.